morning, everybody. Meg Ryan with the League of Cities and Towns. Super pleased to be doing this again with the American Planning Association, Utah chapter. I know some of you may have been at the Utah APA conference last week in Kanab. If so, you're lucky. But Wilf and Scott did a run through on this last week, and here we are doing it again this week. So we have Scott Hess, who's with the APA chapter, and he also works, can I divulge where you work? Do you want that to be secret? He works at North Ogden as the Community Development Director, Planning Director. And then Wilf Sommerkorn, if you don't know Wilf by now, I just don't know what to say. But Wilf has worked in a variety of planning jobs throughout the Salt Lake City and the Valley, and right up here, up the road, and now helps the Utah APA. We're also pleased to have our legal eagle consultant, Todd Godfrey, who's helped us on this bills tremendously this year. So today, you know, when you get on the airplane and they have that little video and nobody watches it anymore about the rules of today, like, you know, put on your mask first, don't put over stuff in the overhead luggage. This is my airport spiel for how we're going to try to attempt this Zoom meeting today. Because like I mentioned, we have a couple of brave souls in the room, but most of you are online. So we're going to try to see how we do this hybrid switch. So the attempt that we're going to do today is we're going to run through a bill and then we'll take questions. But we're going to attempt to have you all navigate the hand button and raise your hand and ask a question online. And if you can't, we'll revert to the chat box, but sometimes it's easier for everybody to hear each other. So that's the first thing. So if everyone wants to locate where their little raise the hand button is, which you all should know now, two years into this pandemic, we're going to try that system. And Carson Eilers of our team is helping me navigate that. And so if that fails, we'll just go to chat and we'll pause and we'll answer your questions in the chat box. And for those of you in the room, we have a mic here that my other colleague, Liam, is just going to hand you the mic when you want to ask a question. So pretty free flow. We'll figure it out as we go. The one last thing I would like to do, since this is a webinar, so you guys can't really see each other, is I have a request. If you guys wouldn't mind online, if you would drop in the chat box where you're from and what your position is. If you're elected, if you're appointed, if you're a staff person, if you had nothing else to do today and just logged in. So if you guys wouldn't mind doing that, maybe we can try a little virtual networking. At least you can see who's online with you. And that helps us also what kind of audience we're talking to. So those are the rules of the road. You can all now sit back and relax. We will be arriving at our destination in an hour and a half. So we will proceed. All right. With that, we are going to launch right in. And let's see here. Hot takes. We did try this last year. This is kind of the first shot of bills that came across the bow that we feel like we really want you to stick in your brain. And I used to always fight Cameron when he would rattle off bills of HB 42, HB 63, HB 72, because I was like, hey, we don't know what all these numbers are. But I have acquiesced and I've put the numbers up there, but we have the names. So I like to think about, you know, one, it's easy to find the bill number on the state website, but two, what does this really do? So the first big one is House Bill 462. A lot of you in the room may remember in 2019, we had Senate Bill 34. That was our big housing sort of bill that relied on 83 cities. Of you 83 cities, you know who you are because you've been submitting reports. Well, HB 462 applies not only to the 82 cities, but also some other requirements. So that's the big one. We will go into depth on that. HB 303, House Bill 303, local land use amendments. I'm not sure why local gets in the title, but they're land use amendments. So you all know and love Title 10, Chapter 9A for the cities, which is everyone pronounces it differently. I say LUDMA, Wilf says LUDMA. It's all the same thing, the Land Use Development and Management Act, where all these laws are written down. For the county, Title 17, if we have any county folks, welcome this morning, Title 17, Chapter 27A. Look at that. See, my trusty panel here. And so that worked on, and Todd Godfrey's going to walk through that for us, but that worked on some new subdivision and text amendment noticing, along with some other wonderful requirements that we will need to deal with. And then Year of Water. And we also are lucky to have our legislative policy director in the House today, Justin Lee, and he helped us navigate a lot of the water bills. We have SB Senate Bill 110, which again affected the general plan requirements for land use for us. We're going to talk about that. And then water-wise landscaping. And there were some other water bills, but when we get to that point, we can have, if we have time, we can have Justin talk to you. But let me also say, we've taken some of these more complex bills and we've done yet another webinar that we're holding. So on our league website, my colleague Susan Wood has done a great job of posting all of the spring trainings that we have coming up. So for instance, on House Bill 462, we will have another hour-and-a-half session just for those 83 cities to walk through line by line item of the bill. HB 303, we will not, because Todd is going to wow you today with all the facts and figures. We will also be able to produce some updated documents in the future if we need to. Last year, we found it helpful to do frequently asked questions. So we may do that for the bills this year, if that helps you all. And then water. Justin, what's the date? We're going to have a deep dive on the water bills. So next Wednesday, which anyone got next Thursday, April 7th, we're going to do the water bill deep dive session. So April 7th, and this is all on the league website, ulct.org. So April 7th is water. April 13th, we're going to have the moderate income housing component for the 83 cities. And then the following day on the 14th, we're going to have one on SAPS. So, I'm not being derogatory and calling you all SAPs. That's what I grew up. I didn't know what a SAP was, but a SAP is a stationed area plan, which is another terminology and affects certain cities that we'll dive into today, but we're going to have a deep dive for them. So today we're a little bit more global, knowing that we're going to carve out sessions for these other issues. Well, that was a mouthful. All right, general plans. Let's get into the bills. I'm going to take the first one and then I'm going to turn it over to Wilf, right? Is that the next one? But let's talk a little bit. And then my colleague Carson also. So what's the big deal on this? So 83 cities. So the 83 cities, I'm not going to name off, but if you're the 83 cities, it's a population-based requirement. Towns are exempt. You have been doing this requirement for the last 2 years. So I know you all know because we bothered you very much right before you have to submit a report. So let's drop back. What did you have to do? Well, there was a menu item that was created. And from that menu item, you had to select a policy decision on how to increase the ability or the affordable units in your community. And affordability, let's get that right off the bat, is defined term in the statute. It's called moderate income housing here under LUDMA. And that threshold that we're going to be talking about today is set on an income threshold. So before you all fall asleep, the income threshold for moderate income housing is 80% of the area median income or below. That's as much math as I'm going to throw at you right now. Okay, so you all had to pick a menu item. You had to pick actually 3, maybe 4, depending on if you had an extra requirement with transit. And a lot of you picked more than 3 or 4. Some had 12, some had 15, some struggled with 3. You picked the 3. So what am I talking about? You picked like one of the items was we are going to look at increasing the ability to have accessory dwelling units in our community. So we're going to get an ordinance. We're going to put it in place. We're going to either adopt it or modify it. So you picked those strategies, you worked on putting them in place, and then you submitted a report to the Department of Workforce Services. So what's new this year? What's new this year is that we added, surprise, some more menu items to give you more flexibility, to give you more options. We combined some because we realized in 2019, some of them said kind of the same thing. So we combined the menu option. Not we, but the Utah State Legislature increased the number of items that were required. So again, we will go into detail on all of these components, but the bottom line is more menu items. And then here's the additional item. There was no implementation tied to those menu items that you picked. So in other words, the state legislature asked, let's see some progress. So one of the changes this year will be actually tying an implementation schedule to that item that you picked. We will adopt an ADU ordinance by. We will do whatever by. So a timeline that you set in order to implement the policies and procedures that you have picked. That new change in the reporting deadline, it's not a report this year. It's, did I pick new menu items? What are they? And do I have an implementation timeline? And you're going to need to submit that by October 1st. Okay. Next year, 2023, we're in 2022, right? 2023, there'll be a new report. And we're going to work with you guys on what that report looks like. We have a new team at Department of Workforce Services, Christine Oliver, and she had just hired a new gentleman named Peter, who is also going to be on the training with us on the 13th. And they are very committed to working with us to make these things right. So we're going to have a partnership on that, which I think is going to be really, really helpful. So that is in a global view, new submittal with an implementation element by October 1st of this year. The reporting period in the future will be tied to your fiscal year, the city fiscal year. So hopefully that will help some of you. Maybe you can align that with your budgeting, with your capital improvement plans. You can look at those policies in line with that. And then next year, we'll have a new report. And I think the big emphasis is on providing data and providing data that really tells our story. We heard a lot of that from our membership. Is like, we're not telling the whole story here. We have lots of units that are permitted. They're just maybe not being built. So what entitled permits do we have? What actions are we taking? So we're really going to work at figuring out a way to get that data into the hands of the state. The other great news attached to this, which is also outlined in the funding, we had an epic year for funding because we've been asking for years for assistance and training and technical assistance. The state allocated money to have the Department of Workforce Services do a robust data gathering procedure to get all their documents online, to be able to come into the 21st century and help and assist us with the numbers that are required for this report so that we don't maybe necessarily have to focus so much on the math, but on the outcome and the policy. So that's a huge win, the way that I see it. The other things this bill did is prohibits impact fees for internal accessory dwelling units. We tried hard not to have lots of acronyms in this PowerPoint, but it's just beyond us. I think as planners, we're helpless. We are stuck with acronyms and we love them. So an IADU, internal accessory dwelling unit, no longer allowed to charge an impact fee for those that are in existing dwellings. Existing dwellings, what does that mean? It doesn't mean new construction. So we played with that term for a long time. Okay, you must also, in this report that we're working on developing, they want to be able to track accessory dwelling unit permit numbers if you have those in your community. DWS, again, we're going to get help. And I really think it's going to help. And then the county had some other provisions as well that were added on to do yet another acronym, HTRZ. Anyone want to take a guess of what HTRZ is? Housing, Transit, Reinvestment Zone. Okay. With that, I am going to, any questions, Carson, should we launch our attempt here? I know, should we see if anyone wants to raise their hand and ask a question of any of us at this point so far? Because now we're going to turn to SAPS, which is the second part of this bill, and Cameron's going to help us understand SAPS. That first while you guys are finding your hand buttons.
You may have said this. So the report that's due October 1st, is that in lieu of the one that we typically submit December 1st each year, or do we need to be prepared to do both?
Excellent question. December 1st is gone. In the past, we're done. No December 1st. October 1st is the new deadline. This year, it's going to be not so much a report in the sense of progress, although we're working on that still. It'll be out by July 1st, but in the next month and a half, we're going to work on that. Basically, it's going to be, here are the menu items I picked. Here's my implementation. So that is the key piece, is that implementation timeline for each element. And that's going to be submitted by October 1st of this year. Thank you. Yeah, a couple more questions here. Carson, any online that we want to field in the interim?
When do we start reporting the ADU permit numbers? Is that this October or next year?
Excellent. Thank you, Eldon. So my understanding as of today is that ADU permit reporting will be asked for. Whatever you have in your inventory will be asked for this year. Okay. Again, July 1st is when DWS has to have that final form in place, but hopefully it should not be too onerous for us to just pull the permits and say, hey, it's this number. All right, we're going to go back to in the room, in the house. We got a question here. And you are?
Brad with Clearfield City. So just a clarification on the October 1st. So you were saying that's the new date, but that's just for this year. After that, in 2023, it's going to be fiscal year, right? Would it be June or whatever?
Excellent. So do I need to? I don't need to. Okay. Okay, great. Excellent question. So it's always the when you have to submit this to DWS from, as far as we know, hopefully, right, Cameron? Because we're not going to change the date next year. It will be October 1st of every year. The reporting period will be tied to your fiscal year. So in other words, as of June 30th, then I have July, August, September to pull the numbers together and submit by October 1st. So we hoped that helped somehow because it was an odd stop before. And we thought that may align with some other things in the municipal schedule. Does that make sense, Brad? Excellent. Good. Hey, Carson, should we try online?
Yeah. Hey, Meg, it's Christina Oliver. I'm here. I'm happy to clarify any of these questions.
Department of Workforce Services to have a question. Christina, good morning.
What have I messed up? Hello. Nice to join all of you. Okay. So yeah, I want to address the accessory dwelling units first. I know that a lot of cities will have trouble with this initially because, just speaking from experience, we didn't have a category for building permits in our software system. In the last city that I worked in, we would capture it as a second kitchen permit. So our expectation for this first report in October 1 is going to be an explanation of how you capture it, and if you capture it, if you have any data that can be provided, and then the steps that you will take in the next 12 months in order to start capturing the data. What we're trying to do is have a holistic picture of units on the ground, which is currently not anything that the Utah assessors, all of the different Utah assessors have. So that's the goal of this particular exercise.
Excellent. Thank you, Christina. And again, Christina, right on Wednesday, April 13th, we will have an hour and a half to answer all of these questions and we'll specially invite each city and we'll go into a real in-depth conversation on this. So thank you. Okay, Carson, where are we at? We're back in the house with Mr. John Jansen.
Thank you. Just kind of following up on that. So existing plus the new permits is what we're trying to report. And existing, a lot of communities won't have information on that unless they have a business license, possibly. And then there's all those illegal ones out there too. So I'm just wondering, what's the expectation for that?
Christina, would you like to respond?
It's going to be flexible this year is the best way to put it. I think on that meeting on the 13th that Meg is having as many people attend as possible, we're really going to start to talk about what's a reasonable expectation. So that's in the works. As Meg said earlier, this process is going to be iterative. My office is not going to be developing the reporting forms in a silo. So we anticipate not only the training that Meg has put together, but also Pete Kane, who's a former planner at Draper City and Eagle Mountain, will be reaching out to select groups facilitated by the league to get more detailed information as to what should be in this first October report. Is that helpful?
Excellent. Thank you. Okay. Any more? One more online. Let's go for that. Levi.
Yeah, I just had a question on the implementation timeline. So what if we already have that in our plan and we've already accomplished it? Do we still need to update our moderate income housing plan with new strategies and new timelines?
Christina, would you like to take that? I have my take, but I think we should go right to the source.
We'll look at your implementation guideline and be able to assess if it's a continuing option, or if you've closed it out. That would be something that we need to discuss, because the reporting requires ongoing implementation. There is no discussion of if one is sunsetted, does another one need to be chosen? The intent is that there are continuous efforts and that one single effort will not solve all of the affordable housing issues. It's not the best answer, Levi, but we can talk to you specifically offline.
All right, station area plans. I think we're gonna proceed ahead with that. And we're gonna turn it back to Cameron. And Cameron, no hour. And again.
Perfect. Thank you, Meg. I mentioned in my comments when I introduced the session that almost every concept that we discussed during the legislative session started during the interim. This is one where a high-level concept started during the interim, but then there was a major shift in the focus through the negotiations of the session. So let me take you back a few months. As recently as early January, there was considerable dialogue at the Capitol about state mandated land use planning around state transportation corridors. Now, before you ask me what a transportation corridor is, it's what you think it is. It's Redwood Road, it's US 89, it's a state-owned infrastructure. So now start thinking through your city. And if you're Farmington City, that has multiple north-south thoroughfares through Farmington City, and you start thinking about the land use planning around those north-south corridors in Farmington City, you start to say to yourself, well, there's not much of Farmington City left if the state is doing the land use planning around those state transportation corridors. Well, over the course of the legislative session, as we were going back and forth around this proper balance of local government and state investment in transportation infrastructure and local land use planning, how to align those, how to build on the foundation of SB 136 from a few years ago and SB 34, et cetera, we ended up in this space that became a consensus space. And we actually repurposed an existing tool in state law that's known as a station area plan that right now is solely optional. So if you're Cameron City and you have fixed rail in Cameron City, right now under state law, you have the option to partner with UTA to develop a station area plan. And the language is pretty vague in state law about what a successful station area plan looks like. During the legislative session, we essentially took that existing tool as part of the deliberation and said, we're actually going to revisit and modify this tool, make it mandatory wherever Cameron City or any other city has fixed rail, set some state objectives as to what a station area plan needs to look like, set an aggressive but doable time frame for what a station area plan needs to look like, but then ultimately leave the decision-making at the local level for how to meet those state objectives. So we're seeing in other states where California, for example, has said there has to be a minimum density around every transit stop, regardless of what that transit stop looks like. So they're treating a transit stop like the Salt Lake International Airport transit stop the same as the Clearfield Frontrunner station, which they're treating the same as a light rail stop in Murray. The nuance of our approach is that, yes, cities have to plan the station, they have to do a station area plan around that fixed guideway, but the plan around the track stop at the Salt Lake International Airport is going to look different than the track stop in Murray, which will look different than the Frontrunner stop in Clearfield. So the city needs to figure out how to meet those state objectives, but do so in a way that's not a one-size-fits-all approach. There is an aggressive but doable time frame, and there will be technical assistance dollars available to communities in order to do these station area plans. And there's a major policy shift here about what happens once you go through that time frame and you enact your station area plan. Cameron City would then not just have to do the plan, but then also enact the zoning, which would then allow that plan to flourish. And once that station area plan is in place, two new things have to happen, two new processes. Number one is Cameron City would need to be certified by the Metropolitan Planning Organization. So if I'm here in Davis County, my city would need to be certified by the MPO, which is the Wasatch Front Regional Council. And the idea here is to say the city is still making the decision. But because transit is a regional asset, and because what happens in one city impacts the other city in how to make the transit system, how to maximize the transit system, there will be this certification process from your peers, which is a different paradigm than the state of Utah stepping in and providing that certification or making that decision. And then the second key component of this is that once the city has enacted that station area plan and started implementing the zoning, those legislative actions are now subject to higher referendum thresholds, or if in Cameron City, more than 2/3 of the city council votes to enact the plan and the accompanying zoning, it would actually be non-referable. So it's still a legislative act. That's an important piece here. It's still a legislative act. It would just be non-referable if the city council passes the 2/3 threshold. So I'll answer the inevitable question, how is that constitutional? Well, under the Utah State Constitution, the legislature has a 2/3 majority threshold that once they enact a bill above the 2/3 threshold, it's non-referable. So you're essentially taking that same standard that exists at the state level, applying it to the local level for the legislative actions around station area plans. We will be doing a deep dive on station area plans in a couple of weeks as part of spring training. That's the high-level overview. The key takeaway for your cities is if you have tracks, or if you have Frontrunner, or if you have BRT with a dedicated lane or the S line, you need to be pouring through the stationary plan language and figuring out how it applies in your city. Many cities have some type of plan already in place. It may not be a station area plan, but you have some sort of plan in place. And the bill is designed to meet cities where they are. So if Cameron City hasn't done any sort of planning yet around transit, we'll be starting from scratch. But if Meg City has already been planning around that transit stop, you would look at your existing plan, you would look at the requirements of the stationary plan, and maybe it's 100% compliant already, and that's what you would essentially report is, yep, we're implementing this, and you self-certify, and then WFRC certifies as well, or you would say, we recognize that we actually haven't considered this piece and this piece of the state objectives, so we need to look through those pieces. So again, it's an effort to avoid the one-size-fits-all approach, respect the role of local government, but hopefully maximize the land use planning around transit to maximize the efficiency of the transit system, accommodate more housing, accommodate transportation connectivity, and access to opportunity. Meg, you look ready to give you the hook.
Phew.
Thank you.
Okay. No, I have a question, but see
you
why
have a
we're
question,
doing
or do you have other people have a
deep
question?
dives on these?
Yep.
I have a question from Corbin from Centerville. If there's a combination of a mixed traffic and fixed traffic system, e.g. BRT, is the potential city having a mixed traffic route only actually exempted?
Yeah, that's an excellent question that I'm going to answer in 2 weeks. And the reason for that is we went through and mapped out the existing network and recognized that the biggest sticking point on the definitions was the future BRT expansions. I'm looking at you. I probably should be looking at the camera. Hi, Centerville. So we recognize that the bigger issue here is going to be BRT expansion, and BRT expansion looks different in different communities and sometimes even within the same community, depending on the lanes. So question received. We'll have an answer for you when we go into the deep dive where we're walking through the maps in a couple of weeks. Carson. Fire away, Paul.
Yeah, can you hear me?
You bet.
Okay. So my question is, we have a station area location that's designated and purchased by UTA, but there's we'll probably have flying cars before we have commuter rail there. And I don't think there's any plan for BRT yet. Are we obligated to do this, or is this only for communities that have stations that are going to be developed within a foreseeable future?
Okay. 2 answers to that. Number one, it's funny you bring up flying cars, because yesterday at the Unified Economic Opportunity Commission, which is a commission the legislature created last year, 25 bills came through that commission, including House Bill 151 on retail incentives. Flying cars actually came up yesterday. So it's funny you bring that up. And there's actually going to be a work group this summer, and the league has someone that we need to fill on that work group about, I'm trying to remember the exact term. Liam, where did you go? What was the exact terms? Like unmanned aerials.
Unmanned aerial vehicles.
Yeah, unmanned aerial vehicles.
Yeah.
And the intersection of state and local regulations of unmanned aerial vehicles, which isn't quite flying cars, I don't think. But anyway,
I was in a session. I
Next
think
Frontier.
what we're talking about.
Oh, do you have something on flying cars too? Oh, okay. Now, setting aside the flying car piece, to Paul's second question about what happens if UTA is looking to buy the property, and the concept here is existing stations and future stations as they come online have to have a stationary plan with them. So if in your case, Paul, Brigham is a decade out from getting the station built, and decade's probably realistically too soon, but if you're a decade out, then you need to have a plan in place before that station opens, but you're probably several years out from starting that process, as opposed to a city that already has existing rail in place. Scott, did you have something? Okay. I was wondering if you were back. Oh, yeah. No, I was. Yeah. just going straight flying cars. Yeah, no, I'm really excited about this whole flying car thing, but John Hiskey.
Thank you, Cameron. A question relative to the zoning or unit requirements at a given stop. There's been some confusion that at one point there had been an arbitrary number,
Yeah.
Of 50 units per acre or something that was quite, concerning to folks. Is that incorrect on that assumption?
Yeah, this gets a little nuanced here, so hang with me. You have House Bill 462, which for cities does not have any minimum density associated with it because of so station area plans do not have any minimum density affiliated with them. So John works for Taylorsville City. If Taylorsville City had fixed rail, which you don't, I'm not trying to mock you for not having it, but you have a BRT line that's coming. So for that station in Taylorsville, you do not have a minimum density requirement. There are objectives that Taylorsville City needs to meet, and then you figure out how to meet those objectives. And the way you meet those objectives may be different at Station A versus Station B, based on existing land use, based on environmental reasons, based on other transportation connectivity, et cetera, et cetera. I mean, that's the beauty of the nuance of the bill and the local flexibility therein. Now, that's different from an HTRZ. And House Bill 462 does have language about HTRZs that don't affect cities. And then there's the HTRZ expansion bill, which is SB140. And SB140 expands the number of HTRZs that can be created in any given county. And so again, using Taylorsville as an example, if Taylorsville City said we wanted, let's not use Taylorsville. Let's use the city behind you, West Jordan. If West Jordan wanted to do an HTRZ and they wanted to do an HTRZ with one of their light rail stations, the city initiates it. Okay, that's a key difference between an SAP that the state requires and an HTRC that the city initiates. So if the city initiates it and meets the requirements, one of which is minimum density, then once the city demonstrates that they're in compliance with the HTRZ language, then the other taxing entities that would be involved in a traditional CRA, school district, county, et cetera, are obligated to contribute part of their tax increment to the infrastructure for that HTRZ. So again, a station area plan is required, doesn't bring the minimum density. An HTRZ is a voluntary tool for cities. Once you go down that path, there are minimums related to it, but then that also comes with certain required outcomes, such as the counties and the school districts having to contribute, and then the state also has to contribute there. So those are the nuances of the two. Stationary plans ended up in 462, but not applying to cities. They only apply to certain counties. What did I just say? Nuts. Yes, HTRZs came into 462, but only apply to certain counties. Okay.
I'm going
That's my hook.
to interrupt the
Yeah, we'll be doing the
acronyms.
deep dive in a couple of weeks.
One quick question for Brian, and this may be another one that you have to attend on the 14th. What if the front runner stop is in another city, but within a half mile of our city? Are we required to do the SAP for the stop?
There is required to be cooperation between the city that houses the stop and an adjacent city that is within the half mile radius. Again, I'm looking at you. I look at half mile. Yes. Hi there. So yeah, this is another new policy piece that is going to be interesting to see how it'll be implemented. I was on a call just this morning talking through what this is going to look like with a couple of particular cities. So yes, if you're a city that doesn't have the front runner stop, but you're within the half a mile of the front runner stop, the city that houses the front runner station needs to consult with you about meeting the objectives of the station area plan. So again, we'll see how this actually operates in practice.
All right.
Okay.
We've made it through the first bill.
Yeah,
Woo!
sorry about that.
All right.
Good luck. I haven't even gotten to the technical stuff yet. So thank you very much.
Okay. I think we are going to head to the next one. So this is just on the slide. It's a recap, kind of what you need to do legislatively and administratively. Okay, but again, 2 deep dives, 13th and 14th. So we expect to see you all there. Okay, these are the actions though you need to take. There's a summary on each one. Is water next? Did I skip one? Okay. So SB110, water. Justin, do you want me to put you on the spot? You want to give a quick recap or you want me to do it? Okay, all right, this is a test. And then he can make hand wave movements in the back. So SB 110, again, Senate Bill 110, water as part of the general plan. There were more water bills, but there are 3 that I think that I think affect us. One is this one with the general plan. One is about ordinances we can't prescribe against. And then the third is a global, more water-related municipal issue on the water metering that, again, we will have a deep dive on. So you'll get all the details. Basically, this is what we're kind of already doing anyway in our communities, but the state has now asking us by 2025 to add to our general plans. You know, we have the mandatory transportation, land use, and housing for some of you, the mandatory elements, and then you pick the other elements that you want in your general plan. But you have a few years to put in place this element. There was money that was allocated to assist you with this. Also, the conservancy districts in your area have incredible model ordinances. We will put together more resources on this and have some links. And once we understand, if Justin doesn't already know the funding contact, we'll have that name in person and everything kind of outlined. If not, by the meeting next week on our Land Use Academy of Utah website, luau.utah.gov. So there'll be money to help, but 5th class municipalities and towns are exempt. In this element, you need to look at the use of water with development in your community. You need to look at conservation measures, look at landscaping provisions and ordinances. Again, I know a lot of you are already sort of doing this, but again, that is the overview of that. Effective date, it goes into effect, but you have to implement on May 5th by the 2025. Again, all cities 1st through 4th class, 5th class cities and towns exempt, but of course we always encourage you to do this. So look at your general plan, look at the water and preservation efforts that you're taking. And again, we will have more information on the contacts for you to get assistance if you aren't already there. Okay, now, Wilf, we have the Great Salt Lake amendments, which doesn't apply to a lot of us, but it's interesting just again in the water vein. So I'm going to have you come up here. And I totally didn't take any questions on the water thing. So you can drop them in the chat kind of so we can move on.
All right, just a couple of comments. One thing you may have noticed that the title of this overall presentation was the year of the plan. And that's kind of what I came up with, because when you look at the legislation that was passed this year, the overwhelmingly significant really parts of the plan of bills that were passed has to do with general planning in our communities, or with the general plan section of LUDMA. How's that? With just to give you a scale or an idea of the scale of the changes. So a few years ago, prior to some of the moderate income housing plan requirements that were included into the general plan section a couple of years ago, the general plan section, part 4, section 4 of LUDMA consisted of about a total of about 85 lines. A couple of years ago, when those moderate income housing plan elements were included, it added about another 65 lines to that section, which almost doubled the size of it, pretty close. The modifications that were made this year added about another 15 or 20 lines or so to the moderate plan section. The water element requirement that Meg just talked about added about another 20, I want to say about 25 lines, 30 lines to section 4. The station area plans requirement, which of course doesn't apply to most communities, it only applies to those that have rail or transit stop within them, but still it's a fairly significant number of communities, added a grand total of about another 220 lines of code to the section 4. I'm going to geek out a little bit now, do some planning geeking. Cameron, we've about turned him into a planner. I think he spent more time on planning issues in this legislative session than he has in the whole rest of his life. And so we're going to make him an honorary planner. But Cam and I on occasion have traded midnight text messages about geeky planning stuff. And so let me geek out a little bit on this. What's interesting, what's happening with section 4, the general plan section of our code, is that we're getting much more detailed. The elements that are coming in are being much more specific and much more detailed in what's required to comply with those elements or to do those elements than what we've had in the past. It's not necessarily a bad thing, but it does mean more work needs to be done and more knowledge needs to be had by those that are working on those, particularly for communities that may not have full-time planners or planners that can spend a lot of time on this. They're spending all of their time processing subdivisions and land use applications. So that's going to be a significant factor, particularly with the requirements that are in place now for when these things need to be done by. I'll give you a little anecdote. I had a friend of mine who just recently said his grandson, it tells you something about where I'm at in life when it's no longer their son. Everybody's talking to me about their grandson now. His grandson is attending school at the University of Washington in Seattle and is majoring in urban planning. And he'd love to come back. And he said, he really is hoping he can get a job when he comes back. And I said, oh, he'll have no trouble finding a job when he comes back, because this is truly the Planners Full Employment Act. There is going to be a lot of work that needs to be done because of the requirements that we now have in these general plan sections. So much so that I even worry that a lot of this work is going to wind up having to be done by consultants, or will be done by consultants, because local staffs just don't have the capability or the bandwidth to be able to get all of this done. And I'm not even sure we've got enough consultants in the state of Utah right now to be able to handle all of this work that needs to be done. So it's going to be a big workload. There's going to be a lot that needs to be done here. Now, the geeky part of this. General plans in the state of Utah have been, up to this point in time, non-mandatory. And what I mean by that is that our communities are not required in their land use regulations to be consistent with the general plan. There are a number of states that are that way. There are a number of states that do require consistency, but it all depends on the legal philosophy and the legal decisions and the way state codes are written, whether that has to happen or not. In the state of Utah, communities are required to have a general plan, but they're not required to follow it, which is interesting. There is actually even a term in the code that even says that they're advisory documents. They're advisory only. There are some exceptions. In some instances, communities can make them mandatory, but there are some ways you have to do that. We're switching philosophy. We are adding elements now to the plan, and the ones that were just adopted into the code this year that have mandatory elements to them and consistency requirements. For example, for the station area plans, those plans that you develop have to be reviewed and certified by the Metropolitan Planning Organization. So that means you have to be consistent with some of the other principles that are out there. Then not only that, you have to within 5 years show how you are going to implement those plans in your land use regulations. That is a consistency requirement. So we have that for moderate income housing plans. It's not quite as strict, but we do have reporting requirements and ways and requirements to show how you're making progress on the policies that you have adopted in your element for moderate income housing. That again comes very close to being a consistency requirement. The problem, I don't have a problem with the consistency idea. In fact, there's a lot to be said about requiring some consistency. What I'm a little worried about is that we seem to be backing into this concept. This hasn't been a conscious decision, or it hasn't been an upfront discussion that we're basically switching approaches in the state of Utah as to how we consider general plans. And what I'm afraid of is that if we continue to do this in a way that we don't explicitly address this philosophy and how to approach it, there's probably a half a dozen different legal philosophies out there and legal approaches to how you go about doing consistency requirements and land use regulations with community general plans. We really need to consciously decide how we're going to do that. Otherwise, I use this example. We backed into some situation a number of years ago with regard to our annexation laws, and our annexation laws are a mess. And they really need to be recodified. I don't want to see us get into a similar situation with our general plan requirements. So just a heads up to everybody out there that if we're going to continue to do this with our general plans, and I don't have a problem with it, I think it's probably a good idea in order to manage our growth effectively, but we need to have a more explicit discussion about how we're going to go about doing this in the future. So just something to be aware of. And be aware that these new elements that are coming in, they're very specific in their requirements about the things that you need to do, the information you need to gather, the things that you need to look at, and the things that you need to adopt into your plan in order to be in compliance with what the code is now going to require with regard to those general plans. Okay, that's just a general geeking out about general plans. Okay, now as well under general plans, we have this House Bill 428, which talks about the Division of Water Resources is going to do a watershed assessment for all of the major watershed areas for the Great Salt Lake. And this is all tied into the effort of basically trying to save the Great Salt Lake because it's pretty much disappearing and has very much to do with how we manage our water or what we do with the water that flows into the lake or could or should be flowing into the lake. But at the local level for planners, first of all, the Division of Water Resources is receiving $5 million in order to do this study and this work. Part of it, they're going to have to cooperate with the local entities because they are to look at the agricultural needs for water, the anticipated growth needs for water, and the economic development needs for water. And much of that depends on what happens at the local level. And so there will need to be some cooperation and some coordination with what goes on, with what the communities have planned, and how they plan to grow in the future with relating that to the need for water and how that water ought to be managed in the future. So that's just something to be aware of. That's another one of those planning related issues that's out there. Another one is the Utah Lake situation. Now this bill has created what's called the Utah Lake Authority, which actually creates a new unit of government. It actually has, it's a political subdivision of the state. The area that it will cover is basically defined as the mean high water mark of Utah Lake. So this authority will have direct jurisdiction over those lands, including land use authority, a number of other things. Well, that may not be a real big concern because what are you going to build in an area that may be under lake water at some point in time? But if there are islands created in the lake, there could be some potential for what may happen there. But there's a whole discussion that's going around that and another bill that was passed related to that. But it's just to be aware that there is an entity now that actually has legal authority to, they will be receiving tax revenue through sales, from sales tax and also from fees that are to be assessed on sewer line connections. So they will actually have a source of revenue. They have the ability to bond, to do all of the things that a unit of government does. And part of what they're also supposed to do is prepare a management plan for Utah Lake. And they're to work with the entities that surround Utah Lake to develop that management plan. So just another thing to be aware of that will directly relate to any planning that may be going on in the communities around the lake with regard to Utah Lake. So I know we're getting down on time, so I'm going to kind of fly through some of the rest of these things. The next thing we want to talk about are, now we're out of the general plan area, which again, I think was the most significant for this legislative session. But as we do every year, we have a number of changes that were made to LUDMA, the way we regulate and with the way we do our land use regulations and land use administration. And we want to talk about those for a little bit so you're aware of those. The first and most significant one, of course, is House Bill 303. Which we also oftentimes call this land use task force bill. Won't go into the details. Many of you are aware of the land use task force and what they have done over the years and what they try to do every year. I will just make an editorial comment that I don't think that's working as well as it used to, but it's still there. It still is doing some things. And Todd kind of managed this bill or kind of helped bring this bill to fruition. I don't know if that's to say that's credit or blame, Todd, but Yeah, but kind of works either way. So I'm going to turn it over to Todd, and he's going to talk about this a little bit.
Thanks, Wilf. It's good to be with all of you. I see 155 online. I suspect that 2 or 3 are from my office. They like to take screenshots and heckle me when I get back. I'm the proverbial face made for radio, but it's really good to be with all of you. Carson, as people have questions, if you would raise your hand and just let me know. I prefer to work with interruptions as we go. It's easier for my flow. You know, the stand-up comedian who doesn't prepare anything and just works the audience. Thank you. So the first thing in the land use task force bill, the LUDMA bill, is not LUDMA related. It's the annexation provision. We had some situations develop, and I think most of you know what gets pushed to the legislature right now tends to be sort of problems that have arisen somewhere. And we're legislating by anecdote. We're all acknowledging that. That's the way it's working now, and it's difficult. But one of the things that's come up is we've had annexation challenges that courts have heard from people who don't have any statutory standing to protest an annexation. And that's a difficult position to be in. So LUDMA makes a change. It makes now law that you have to have standing to protest an annexation to bring a legal action to do it, and you have to have brought your protest action administratively. We'll see what the courts think about that. They tend to think that they're in charge of standing and not the legislature. There's always a little battle there. But that provision is part of the general land use task force bill. There's a change in the definitions of a land use decision. This is a geeky legal point. And for planners, there's kind of a practice note. For city attorneys, it's a little more nuanced. We had over years and years and years with our old provisions in LUDMA before we defined a land use decision. We had developed a body of case law that distinguished between challenges to land use approvals and enforcement actions that may relate to the land use code. And we had a good body of case law that indicated people couldn't use the enforcement action provision, which does not have a defined statute of limitations, or in other words, a time period in which you had to file your action. You couldn't use that enforcement provision to challenge a land use approval. We had situations where folks would fight a land use application, they would lose, the land use application would be approved, and then in the middle of construction, 9 months later, they would bring an enforcement action and say, you're violating the zoning ordinance because your approval didn't match our zoning ordinance standards. That was troublesome, right? And our courts developed for us a good body of case law that says you can't use that enforcement action to retroactively challenge land use approvals. With the definition of land use decision in LUDMA that got adopted around, I think, 2005-ish, maybe, or a little later than that, we started to lose some of that case law. And we had let slip into the land use decision definition, enforcement actions were land use decisions. And so we lost that benefit. This amendment strikes that enforcement action from the definition of a land use decision. For those of you who are planners, code writers, community development directors, if you have a provision in your code right now that provides an administrative appeal route for enforcement actions, don't get rid of it. This statute doesn't mean you can't still do that, but it does mean it doesn't technically meet the definition of a land use decision. And what that will allow us to do is if somebody tries to bring an enforcement action, we can argue a more favorable standard in the district court. Instead of a substantial evidence standard now, we can argue an abuse of discretion standard, which is very favorable for cities and is helpful. The other thing I would tell you is if you have folks appealing building permit grants under kind of an enforcement section, please be careful as you analyze those. And if they're appealing a building enforcement that is truly related to construction codes, then put them down the right route from Title 15. If their appeal, while it's brought on a building permit, really relates to zoning conditions, and most of them do, then handle that accordingly, right? Let's get those in the right place. So that's the one takeaway I would give you from this part of the LUDMA amendment. That's true.
Yeah.
Wilf just noted, and I'll just say the county part of LUDMA did not include this amendment. And what I would tell you is the story's not completely written on this. This is something that's going to be ongoing in interim and is going to continue to be discussed. 1098-205. imposes a requirement for their text amendments to the zoning code now. With the notices that we post, we have to include a short summary, easy, designed to be understood by a layperson, of what the text amendment does. So we've had and this is again, anecdotally, that's how this got pushed up. We had situations where folks were amending text amendments or amending the text of zoning codes in a way that substantially altered the development rights within a particular zone. And property owners with properties in those zones just weren't, the information wasn't bubbling up to where they could make meaningful comment to a council about what it meant. And so this amendment is designed to address that. There's one quirk with this that I think we're just going to have to figure out. When we post the notice on the Utah Public website, it's really easy to include that short summary, right? When you put the notice on your city website or your town website, it's easy to include that summary. But there's still a public posting requirement for 3 places within the public, I think. Is it 3 or 5? 3. I guess just put your summary on the back of your notice, right? I don't know what else to do right now. It seems weird, but it'll work. And it's compliance. So I don't think this is terribly substantive. I don't believe it adds a horrible burden, but you need to add this now to the list of things you do every time you have a text amendment that comes up. So John.
I mean, let's just say you're amending 7 or 8 ordinances at once. What do you think about that?
I would be writing my summary in a general way if that happened, right? There's no page limit on the summary. There's no real true defined content other than a summary designed to be understood by a layperson of what the effect of the ordinance changes. So, try to be faithful to it and do it right. But again, I don't think we need 10-page summaries. Now, I've seen really comprehensive omnibus text changes, right? Lots of people do those, and sometimes they do them yearly and everything else. I think your summary I would do bullet points in that kind of a case. So as a side note, this came up because of a city that amended regulations relating to a sensitive lands overlay zone. There's a property owner whose property he felt was tremendously affected by these changes. And without talking to the city attorney or the city planners or anybody else, they went right to a legislator and said, these guys 3 years ago stripped away all the rights of development on my property. And that's how this legislation started to get pushed up. The reality of that situation was that property and almost every other one in that city sensitive lands overlay zone was governed by an existing development agreement. They grandfathered it. So just, this is just one of those things that we're reacting to with the consistent pressure we get at the legislature. 10.98212. This was a significant part of the discussion in the land use task force this summer. It relates to developments or subdivision improvement standards, development standards, your how many inches of asphalt, how wide your sidewalks are, pipe sizes and things like that. This requires that the amendment to these standards have a public hearing. That public hearing has to have 30 days advance notice, and the notice has to be mailed to active land use applications. So if you've got a land use application that's been decided, approved, denied, whatever, you don't mail to them. Everybody else that's in the queue, application has been filed, you've accepted a fee, it's complete, they get notice of the change of these standards. You also have to send notice to anybody who's asked to get that notice in writing. I don't think we're done on development standards either. I think this is going to continue to evolve. The push in the land use task force this summer was for the state to adopt a uniform set of standards. That doesn't mean the same road standard in Salt Lake as St. George has, but it means adherence to some set of uniform standards that might have some flexibility. That sounds like a nightmare to me. And so we've kind of tried to dig our heels in, but this discussion isn't done. We're going to keep getting pushed from the development community. And you can understand when we change the asphalt thickness on our roads, that's a cost that directly hits a developer. And we all understand that. We get it. If we change the width of our sidewalks, that's a cost that hits them, and we get it. the thing we're hearing is that sometimes these changes are relatively arbitrary and that they're imposed, I guess you could say sometimes as a penalty and sometimes without consideration for what they're doing to a development overall. And unfortunately, in my practice, I've seen that in real time. I've seen that actually happen. And I've seen standards, imposed or pushed by a fire marshal or an engineer or somebody that candidly I couldn't look at and find real solid justification for. So be cautious about this. I'm sure the discussion on this one isn't done, but that's where we are for this year. In the 2021 session, we had a troublesome provision on subdivision vesting, a 10-year kind of vesting provision inserted into LUDMA. That's gone now. This bill takes care of that. That discussion is not done also. So to put this on your radar, there has been an issue for a long, long time about what exactly vests for a developer when a subdivision is approved. Do all the setbacks vest forever? Do building heights vest forever? Does the use vest forever? These are questions that aren't really answered very clearly in our law. And there's a lot of discussion about that. There's angst from the Property Rights Coalition folks about our pulling uses out from under people. They get upset about the fact that they start to develop a neighborhood a certain way, and it may be 4 years or 5 years before another building permit's issued. And if we change our setback regulations during that time, we upset the look of a neighborhood. We change height regulations from time to time. Those are the kind of questions that are circulating right now and are a little difficult to answer in our law. They're not very clear. So I think there's going to be ongoing discussion about what this means. But the 10-year provision for now is gone. And candidly, I think that benefits both our cities and the development community. There was a change made in 10-9A-511 relating to non-conforming uses. And I'm just going to be candid in this wonderful company of friends. We have for a long time put private property owners in a box on this issue. When they come in and say, I have a non-conforming use and I've used this property as a duplex for 50 years. Our position has been frequently, prove it. Show us that you lawfully established this use 50 years ago. Well, how do they do that? Right? And so we have an amendment now that makes it clear that the substantial evidence standard governs these questions and that the evidence is not limited to our records. So a property owner can present other things. What I hope for all of you is you have good records so that when a property owner brings something that we may not wholly trust or have faith in, we can look at our own records and say, no, look, we have building permits. This was a single family dwelling 50 years ago, and we don't have any approvals that show it moving to duplex. So that's what that means. I hope that's not really a ground shaking change in the law. It doesn't feel to me like it is. And I hope it doesn't change practice too much. Section 535 is inclusionary zoning language. This is one of those things that could have gone 1,000 different ways when we started to talk about it in April last year. And the end result, I think, is kind of innocuous. If you have sort of a mandatory or other kind of inclusionary zoning provision in your codes and you're grandfathered, great. If not, please understand you have to do it basically by agreement now. We don't get to mandate without providing incentive to the developer that helps them close the gap on, what their pro forma might have said before this. Cam will tell you for sure this one's not done. We're going to hear lots more about this. The whole affordable housing crisis really is affecting so much of what's happening in LUDMA. And you can see that in our bills. It's really clear. There's a provision in LUDMA now with this bill that provides that you can, by ordinance, say that a lot combination does not have to be done by plat amendment. I think some people were just doing that for a long time, but now it's explicit that you can. I think that's a good provision for a lot of us. I'm not going to dive into all the surveyor stuff in 303. Read through that. Boy, we hope that one's done though. We hope we're done with the boundary adjustment, lot combination, and all that stuff. That occupied 4 people's time, full time, for a month right before the session started, and it's been a difficult thing.
We're never done.
Yeah, We're never done. You're right. The one thing I would tell you just to pay attention to, if you don't have a condominium ordinance in your city or town, you're not going to be able to just reject the condominium application now because they can proceed under state law. So if you want to be able to regulate condominiums, you don't have an ordinance, go get one and adopt it. Most people have those, so I don't think that's a tremendous burden. The last thing in 801, we had a situation in 801 is our land use appeals section. It talks about district court actions. We have a situation in there where we distinguish between legislative and administrative appeals of legislative or administrative actions, and the presumptions and the statements were different. But in those sections relating to administrative appeals in district court, we had both a presumption of correctness of the decision and a provision that said the court, shall uphold the decision if it's not arbitrary and capricious or illegal. And with both of those provisions in 801 and applicable to administrative decisions, the PRC has been concerned and has started to argue, and it's actually, when you look at some of the decisions, hard to dispute, that we were starting to equate in the minds of jurists the legislative and administrative distinctions for the standard of review. So our substantial evidence standard on an administrative appeal, because of that, both presumption and the court shall uphold language started to look a lot more like the legislative standard. How do I do it? I haven't been moving anything. Am I supposed to be moving anything? All right. Anyway, so what happens at the end of the day is we keep our presumption language, but we lose in the administrative appeal standard, the court shall uphold the decision. I think this is semantic at best. I don't think there's any substantive change. I doubt there's any jurist on any bench in our state who will be persuaded that this means something. But it crept into the bill, and I had a really hard time arguing why, given what I think it was anything really truly mischievous. So, absent the surveyor stuff, that's kind of where we are with LUDMA. I think it was from where it could have gone. I would call it a fair, safe draw with LUDMA or LUDMA, if you're from Canada. But that's kind of where we are. Are there any questions I can answer before I turn it over to Scott? One here. Liam's running the mic over.
And I think we were good online because you answered everything in your.
Again, Brad McElrath with Clearfield City. So as you talked about the improvement standards, I know a lot of our city engineers, they like to have that discretion of these are our public improvement standards. We don't want to have them codified. And this has been a thing that's gone back for a few years. But from what we understand as planners, I just want to clarify this, is that we need to adopt those by public hearing, needs to go through that public process by city council. And we need to make sure that anytime we make those changes, if we have a developer that's working on a subdivision right now in our city, they need to be noticed of it. And I would say even if we have a land use application in for a subdivision, we would need to notify them of those standards that might be changing.
Completely agree. And that's the whole thrust of what's happening. Just so you know, every time we tell a developer, you have to do this to get your approval, we're exacting something from them, right? And that exaction still has to be proportionate and lawful. So our engineers desire to have an extra 2 inches of asphalt just because, we really have to justify those things, or they move from the standard of just being exactions to being unlawful exactions. And that's not where we want to be, obviously. That's the bad place. So anything else?
Excellent. So I think this is the Speed Reader's Digest version of land use summaries of bills.
Yeah.
We'll go through some of these, and then maybe what we should do is just hold some questions at the end or go through the chat box for those of you online. But again, myself, all of us are available. And at the end, I think we have our emails up, but we're going to turn it back to Scott and Wilf for rapid
Yeah, we
summaries.
both came up, we decided, because I felt bad that Scott hasn't been able to say anything yet. And we are running out of time, so we'll try to go through this fairly quickly. And by the way, I think I have been converted. I will now call it Ludma from here on out. I don't want to be known as Canadian. And I also I'm putting Diddy in my mind. It's not lewd, it's Ludma. So there we go. All right, Scott, take this one.
So House Bill 282, Water-Wise Landscaping Amendments. This is an interesting one because it ties our general plan, water planning over the next 5 years with local land use ordinances. So I think this gives us an opportunity to leverage some of the local pressure that we've been feeling or some of the anxiety that our residents and cities have been feeling to think through our ordinances, also at the same time that we do our long-range planning. An interesting thing about this one, we cannot as cities prohibit water-wise landscaping, which is defined, and we can't require turf in areas that are less than 8 feet wide. So this presumably for most of our cities is our park strips. This is the automatic rip your strip bill. And also I believe I want to confirm, but this is applicable to associations as well, to include homeowners associations. So if you live in a homeowners association and you've been told by your city that you can't do the rip your strip or check your CCRs, this circumvents that. Effective May 2022, it affects all cities and towns. It's legislative and administrative. This doesn't have a time frame, I don't believe, but it's one of those that it's automatic now. So if you have ordinances that go against this, state code can trump your local ordinance in this particular case. So you'll want to review that and get it updated in your local ordinances.
So the effective date of most of these bills, unless there's another provision or implementation, is May 5th, right, Cameron? May 5th, May 4th, May 4th. So you have it till May 4th, but.
Was there a question back for a minute? No? Okay. All right.
Anything else,
Good.
Will?
Nope. This bill is pretty simple. It just requires that anytime you issue a land use permit that affects a designated wetlands, that you have to submit a copy of that permit to the Utah Geological Survey. Pretty simple. All right, let's talk about some other bills. Meg's already talked about HTRZs. We won't go into this in great detail, but this bill expands the ability to use HTRZs in various kinds of transit stations, not just the front runner or station. There's a lot of tax increment provisions in there. The interesting thing from a planning standpoint is that in order to implement an HTRZ, that there is a study required for establishing that HTRZ. And the bill also says that as part of that study, you have to look at parking. You have to do a parking analysis for the area, which is really pretty interesting. And then it also requires that your zoning, before you establish the HTRZ or can establish it, the area has to be zoned appropriately for the type of development that you're anticipating for the HTRZ. There's going to be a deep dive session on this as well. On the economic development modifications, again, this deals a lot with the kinds of things that can receive an economic development incentive, state level incentive, or even local incentive. And who's responsible for defining that and doing that. Just a thing to note there is that in order to receive the incentive and to establish what's called an economic development zone, it requires that the local government had done a long-term plan for that area to address transportation, infrastructure, workforce development, and housing needs, which is interesting that the housing needs are getting tied into this, but it's very appropriate just to be aware of that. Cameron will attest to this. This was a long and bloody fight on this bill with regard to retail incentives for retail development. Many local governments have offered or have used retail incentives for retail development. The initial draft of this bill would have completely prohibited incentives for any kind of retail development. And that's where the long and bloody fight came in. And a lot of things were changed and agreed to or grudgingly agreed to, but just be aware that there are a lot of conditions or a lot of provisions that apply now in able to offer incentives, local government incentives for retail development in your community. There are even some housing requirements that are tied to this. There's a lot of detail about this. It really is quite detailed. If you're involved in this, there'll be a deep dive session on this as well. And you ought to be aware and be involved in that one.
And one thing on that housing that continued to be a questioner as we looked at this was, can we capture existing housing around developments in order to redevelop the kind of lower investment portion? And the answer was no. It has to be additional housing units on top of the existing that are there.
Food trucks seem to come up every legislative session, just like short-term rentals now seem to come up every legislative session. This bill addressed it and then got something tacked on at the end, which was completely unrelated, but that's kind of not unusual for legislative bills. All right. What this bill does is now it adds to the definition, or what's considered to be a food truck, ice cream trucks and food carts. So they are now included in that definition of food trucks. Food trucks under this bill now, they only need to have one business license issued by whoever issues it first. That's all they need to get. Nobody else can require them to get another business license in the community that they may operate in. So if you want to get the benefit of getting the fees of those business licenses, have a fire sale on your business licenses for food trucks or something, but they're only required to have one. You can't regulate the size. And you also cannot require, in order for them to get that business license, you can't require them to show how they're going to comply with land use regulations. That seems maybe counterintuitive, but when you think about that, many food trucks go to multiple jurisdictions. Those rules may be different in those communities. And so it may be overly burdensome to have them show how they're going to comply in every community they might go into, since they're only required to get that one business license. That does not mean, though, however, that the communities cannot regulate. You still can. You can still regulate how and where food trucks go and operate. You just can't require them in order to get that business license to show how they're going to comply to that. And then the last thing that was tacked on had to do with ATVs, which was just really off the wall. But it's tacked on there, and you can see the provisions for that. Again, on the Utah Lake, when I talked about the authority having land use authority over the bed of the lake now, one of the provisions that may be of interest, concern, whatever your perspective is that there may be islands, or potentially could be islands created in the lake. And the idea from a particular proposal has been to do development on those islands. With that authority, exercising that land use authority, it would be up to them as to what and how that works. There was a lot of skepticism expressed in the legislature about that concept and about things and so on. And so what they did was this bill was adopted, which now defines a much more detailed and you could even say burdensome process before any sovereign state lands can be transferred to private ownership. So in other words, if somebody has a proposal and they go forward and they create islands in Utah Lake, before they can get ownership of those islands and do private development on there, there's a whole process they have to go through before the state could transfer any of those lands to private ownership. Won't go into a lot of detail on this about homeless services. Just be aware that as far as local land use regulations go, it prohibits local governments from imposing any capacity limits on seasonal overflow shelters. And it also creates a procedure for winter overflow shelters in Salt Lake County. Other bills that are passed that have some impact on local land use planning. Here's a list of them. They're interesting bills. We're out of time. We won't go into detail on those. Along with that, here's a list of bills that also did not pass. And some of these will surely come back in the next legislative session. Two of the bills which did not pass right there in the middle, short-term property rental agreements and short-term rental enforcement. As we say, that the short-term rental, essentially the Airbnb stuff, seems to come up now every legislative session. And we're sure it'll be back, as well as some of these other bills too. These are some of the issues that we think will be discussed and will be of concern or of interest during the next legislative session. One of the things to be particularly aware of is that the Department of Workforce Services, through the housing office that Christina Oliver will be running, is required to submit a methodology to the Commission on Housing Affordability, which is now a subcommittee of the Economic Development Committee. They have to submit a methodology on how to measure moderate income housing compliance. And so that'll be of interest to see what they come up with and how they do that.
And we, again, on these interim issues, led by Justin Lee of our team, we will be reaching out to the membership on these issues for participation, discussion, endless subgroups and task force, but we will be getting input as we move through these. And again, we have a great commitment from the Department of Workforce Services to work with them. And so we're really looking forward to that partnership.
Todd mentioned, of course, the engineering standards and some other things. Annexation, I'm certain will come up because we already know that the speaker was concerned about a case that went forward in Davis County on annexation and with some provisions that are in the code. Honestly, the whole annexation code needs to be rewritten and recodified, but I don't know that there's any capacity or desire or willpower to be able to do that this session.
I thought you were doing that, Wilf.
Yeah, my wife keeps reminding me I'm supposed to be retired, but and this one, it probably would take a lot of work, but billboards may very well come up depending on what the U.S. Supreme Court decides in a case that they have before them that involves Reagan outdoor advertising, no less. So we'll see what happens with that one, and that may mean some changes in the state code on billboards coming up and other things as well.
And this was kind of the year of planning money. As Meg mentioned, we want to really give kudos to our local partners as well as our UDOT, UTA, and MPO partners who have helped with technical assistance over the years. I think that those successes have led to these legislative dollars and awards that we've received. So we'll see additional technical planning assistance through UDOT, additional technical planning assistance through our AOGs. You've got the water element technical assistance through the Division of Water Rights. There's an entire statewide conversation about growth being funded with $1 million that I think will involve all of us as local governments. Regional workshops on land use, efforts to increase housing affordability through local zoning and housing regulatory reform. And DWS received money to create a housing database that will hopefully turn that data into something that's really useful as we look at our moderate income housing plans and rely on DWS data to help us in our local governments as we create those. And then thank you all very much.
Meg, we'll turn it back to you.
Great. Thanks, everybody. And then we just had one question online about eminent domain and removing parks from eligibility. Will that come back? Yes. Death, taxes, eminent domain, and trails. Always, always, always. Here's our contact numbers. Let us know what we can do to help. Carson and the whole team here, thank you for running all the technical stuff. Thanks for sticking with us. More to come. I know this was high level. Reach out to us. Look at the league website for all of these other deep dives. And this budgets are being done. So this is the time for planners to ask for a raise. Just saying. Okay. Anyway, Godspeed. Thank you. Thank you. Thank you. We're going to end this Zoom portion and be here in person. Thanks, everybody.